Hello and welcome everyone to this roundtable jointly hosted by India Business Law Journal and Ikigai Law. I'm IBLJ's editor Gautam Kagalwala. Today's discussion is about data protection compliance in Asia. India is examining the fourth iteration of the draft data protection law, and many countries in the region have either introduced or on the verge of introducing new data protection laws. To speak about this, we have a distinguished panel of experts who advise companies on implementing global privacy programs. Scott Warren is a partner at Squire Patton Boggs in Tokyo, specializing in data privacy. Michelle Chan is a TMT of counsel based in London at Bird & Bird, who has considerable experience advising clients on global protection issues, data protection issues. Kritiyanee Buranatrevedhya is an IP and tech partner at Baker McKenzie's Bangkok office, and she focuses on data privacy and protection. My thanks to our panelists for taking the time to join us. And finally, I would like to introduce our moderator, Sreenidhi Srinivasan, who is a partner and heads the data practice at Ikigai Law. Over to you, Sreenidhi.
Thank you so much for those introductions, Gautam. Hi, everyone. It's lovely to be here. I have an excellent panel of privacy experts from around the world with me here today. And over the next hour or so, we will dig into some themes around global compliance with data protection laws. Each of our panelists have advised on data across geographies, across several countries in Asia and around the world. And our objective really is to get practical, actionable tips, suggestions, ideas on how to go about data compliance. Where do we start? What are the steps to pursue? Like Gautam said, India is also in the process of finalizing the data protection law. We're on a fourth iteration of a draft law, which is in the works, which could be enacted this year. And we're hoping to get ideas on how to approach compliance for businesses that are data rich, starting really from scratch when it comes to privacy hygiene and several others which are on different stages of their journey in privacy compliance, but particularly those that are global platforms or global businesses which have operations or ambitions to launch across geographies. And I guess just to kick things off, I think there are over 150 odd data privacy, data protection laws across the world. For tech businesses that really want to go global, I was wondering if maybe, Scott, I could invite you to kick things off on how should they sort of think about privacy compliance? What should they start with? Is there a strategic way of thinking about data governance within an organization? Scott, if I could invite you.
Sure, and real pleasure to be on the panel. And also, when I first saw that Sreenidhi was with Ikigai Law firm, I thought, oh, it's a nice Japanese law firm. Ikigai sounds like a Japanese name to me. I've been in the region for about 30 years, makes me feel really old, but based in Tokyo and Shanghai. And I'm looking after the data privacy offering from Squire throughout APAC, but then tying it up with our US and European and other firms. And I think from a law firm standpoint, we're in the top 10 of most global firms, means we have a lot of offices in different countries. And for me, that's really important. I know Bird & Bird and Baker as well has a great footprint. I encourage you, if you have a global issue, try to find a firm that has a global footprint, because the data that you hold is likely global. And we're going to be talking today about why it's complicated. I spent 13 years in-house with Sega and Microsoft, and I really feel sad in some ways for the in-house counsel now, because it used to be we just were worried about GDPR in Europe, and then we'd worry about the US because of the high penalties. But really, in the last, probably 10 years, there's been an explosion, and with probably in the last 20, there's a number of other APAC countries that have their own data privacy laws, which are quite challenging to follow on. So over time, it's come to me that there's a concept I think of called the data privacy continuum. I used to think of it as, digital, right? A or one or zero, right? It was either Europe or American or something like that. But now I see it as a continuum. You've got Europe that sees data privacy as a fundamental human right. And there's a lot of reasons for that. Some people say much of that is because of abuses during Nazi Germany and other timeframes in that. But at any level, on a European scale, it's viewed as a fundamental human right. I actually think the US views it as a fundamental corporate right. But God forbid you miscollect it, you lie when you collect it, you abuse it, or lose it, because you're going to be sued with class action lawsuits, with shareholder derivative lawsuits, penalized by government regulatory authorities. Facebook, I think, paid $5 billion not too long ago on a US privacy issue to resolve it. So look, you don't want to lose it or abuse it in the United States. But then we have these jurisdictions that are China, the new law, as well as Russia, old law, that are much more looking at data privacy as a fundamental state right. And the primary purpose is to try to protect the information in many ways locally or keep access to it. And there certainly are elements of individual privacy in each of these jurisdictions or these spaces on the continuum. It's not like Europe's not interested in state privacy issues. Look at the Schrems cases that challenge the US access to European data that might be located in the US for a very small sliver, at least considered small in the US, considered too big in Europe, largely because of the WikiLeaks and other things that shows the monitoring that was going on. But at any rate, it's a small sliver in the US where data can be accessed without an independent judicial order. And so certainly Europe is very interested in that. It's really curious to me because Europe should be far, far more interested in the access to that data in China, where you don't need an independent judicial order to get the data anyway. If the police go to either the individual company or go to the ISP, they're going to get the data without any independent order. But at any rate, Europe certainly has a focus on protecting the state secrets or state side of that coin. The US is complaining about Huawei and all the things that might happen with routers that could be used to take data. Frankly, Cisco could do the same thing if they wanted to. So this all becomes a matter of who you trust. But the US certainly has a state located interest. And China isn't just about states. There's many things under the PIPL, which I know we're going to speak today, and Michelle will dig deeper in, which are about individual rights for Chinese and how they can access data and things like that. So the thing that's helpful for me about this continuum is if you look at it, you can see kind of where each country's laws that are passing fall within it. And for a lot of APAC, Japan, for example, and a lot of other places, I see them trying to straddle the US and Europe side of it. They want to follow Europe so that they can perhaps get an adequacy finding, but they also want to have free transfer of data to trusted sources in the US style. And then we see some places that, we wonder where they fall. Certainly Vietnam is much closer to the China state protection side. And there was some concern with the earlier draft for India that it was somewhat of a localization rule. And so, and that seems to be relaxed somewhat, but we're still waiting to see how that actually passes. So, but if you can think of it within that continuum, it really helps you figure out, okay, these are the fundamental hot button issues with this country. By reading the law, I know where their focus is, and then it can help you kind of design some common themes through that.
Got it. Thanks very much, Scott. And I, of course, do have a fair few follow-ups, but I'll come back to you, maybe just getting sort of opening remarks from Michelle and Kritiyanee as well. Michelle, I'll come to you with sort of a variation of this question. I think Scott spoke about this continuum, those different triggers or different objectives that different regions might have. I was wondering, again, how would one sort of be able to glean out a common minimum baseline? And are there, differences or similarities that have really stood out to you in the privacy laws of any particular country in South Asia or the world? And from a more practical standpoint, I think Scott kind of mentioned step one, which is just understanding those objectives. But what might be step two then? How do you then account for those outliers and differences?
I think if you look at the overarching data protection laws in some of the major jurisdictions, the EU, the US, Japan, Korea, and now China, what you see is actually there will always be some common common parts to the data protection law. So most of them will define what personal data, personal information is. Most of them will try to distinguish between data controller and data processor. But of course, there are also jurisdictions that don't draw that sort of distinctions. And then you have some data protection principles. Some countries have 10 of them. Some only have 6. Some don't call it data protection principles. They're just embedded somewhere in the law. And then I think EU data protection lawyers like to talk about the legal basis. Now, different countries will have different legal bases. I think it's always a shock to my EU colleagues that there is no legal basis for legitimate interest under China's PIPL. I'm not sure if there is going to be one in India, and if not, what happened to that? And then, of course, you also have rules about notification, data subject rights, transfer rules, governance. So the framework actually is very similar. But as Scott has already said, because different governments pursue different objectives, the substance of that sometimes will be slightly different. But are there lots of differences? I actually don't see lots of differences, but to the extent that there is a difference, there is always a reason for that. For example, the local data localization rules in China. Yes, there is one, but is it as aggressive as the one in Russia? Not really. And then when you take a step back and look at the reason behind why isn't the rule as aggressive as the one in Russia, is because there are Chinese companies that are based everywhere in the world. So having a very stringent transfer rules are not going to help their own companies. So therefore, the rules are slightly different. And I think that when it comes to India's upcoming data protection law, I think that sort of framework would be useful. And then for data protection lawyers that are already very familiar with the GDPR, it's actually a good thing, because then you can draw the differences and then try to understand the law. I don't think the law of various jurisdictions is that different, because the GDPR almost sets out what we call the gold standard, or the golden standard. And I think a lot of the countries are also trying to pursue that. And as Scott has said, sometimes a country simply wants to have a law just to show that it's a modern nation. It isn't lagging behind. So that's my thought on this particular question.
Thanks for that, Michelle. And yeah, on India's law, we also don't have a legitimate interest ground, but we have something called reasonable purposes, which are sort of hard-coded in the law itself. But remains to be seen if that'll do it. But just, I guess, also bringing in Kritiyanee, I think Michelle listed out a couple of these common themes. Typically, the law will be focused on personal data protection. There'll be some core basic data protection principles, say, limiting the purpose for which you're collecting data, minimizing the amount of data used. Often there's this concept of privacy by design or by some other name in different regions. I'm also wondering if there are sort of trends to glean from regulatory enforcement actions. How do you glean out that common minimum? What have regulators been most concerned with as well? And I was wondering if you could come in from the Thai PDPC, Personal Data Protection Commissioner's experiences as well. I understand that a lot of GDPR fines are often about security breaches or direct marketing. So I'm just wondering if that's also something that could aid sort of compliance efforts.
Yeah. That's correct, Sreenidhi. So for Thailand, the Thai PDPA, the law itself, has drawn certain concepts from the GDPR, but obviously all of the devils are always in the details, right? So even if the concepts are similar, it doesn't mean that the details of implementation and the details of Thai law cannot be deviated. You can see from the law itself that even the age of minor, even the exception for minor, personal data processing would be different from those in the GDPR. There are also certain discrepancy in terms of sub-regulation issued last year under the PDPA by the regulator itself, that a lot of details are different from the GDPR itself, meaning that one of the key problems that business operator that operate globally will face right now is that the difference and discrepancy, even if they already implemented their local compliance program to be in line with Thai PDPA, and they still spot some difference from their branches that located in the EU region as well. That being said, leading to the trends of possible enforcement in the future, that for some companies, even if they are aware that Thai law drawn some concept from GDPR, they might not yet be aware that the details are different and the latest sub-regulations are different. When they believe that they already comply with the GDPR, they believe that they don't need to do anything further for compliance with Thai law. So that could lead to one of the problem that might lead to the actual enforcement. And another trend from the Thai PDPC, the regulator itself, is that although last year the Thai law itself has already been in effect after like 2 years of postponement, but you will not see that there is like an actual enforcement cases yet by the Thai PDPC, because last year the Minister of Digital Economy, who oversees the PDPC in Thailand, announced officially that during the first year of the implementation of Thai PDPA, they will not heavily enforce the law because they understand that the law is new in Thailand. Unlike those countries in Europe or in US that you might be equipped with data protection mindset already, but Thailand, this is like the first consolidated law ever. So most business in Thailand, they are not aware yet of how the concept of data protection would be, let alone the consumer side, that they are aware that the law is there, but they still like exercise some right. That during the last year, I saw that the end customer still exercise some rights that is not there in the law. For example, the law similar to GDPR, they enable the users to ask for right to access, right to deletion, and right to restriction, blah, blah, blah. But some end users still write to the business operator and ask for them to like grant their loan amount more, but citing Personal Data Protection Act. So that's where some awareness in Thai end customers should be enhanced as well. So by all of this reason, the trends from the PDPC last year was focusing on the educating the business operator side and also from the end customer side as well. But because late last year during like November, December, there are various sub-regulation issues. So in the course of this new year, the regulator also mentioned that after 1 year and after the sub-regulation has finally been issued, they will focus more on from the educating, from raising the awareness into data breach enforcement more, because they know that for when the data breach happen, it might affect public as a whole. So this is another trend from Thai regulators, Sreenidhi.
Got it. No, very useful. And I think in India also we might see similar, because we have to build that sort of administrative capacity, culture of privacy and awareness within businesses, consumers, before we can even get to a stage of sort of enforcement. And I think all of you have talked about how there's this perception that GDPR is like the gold standard in the world. But I think we're all in agreement that I mean, it's not as though compliance with GDPR will get you to be compliant with the laws of every country in the world. In fact, there may be some outliers, several instances where regional laws are more stringent than what the GDPR requires. But I'm just wondering, and maybe Scott, if you could chime in here on, are there any sort of baselines that we can actually draw from the GDPR then, maybe basic principles like data mapping? And would you really advise businesses to look to the GDPR, even if they have no operations there in the foreseeable future?
Yeah, so I think the question is it the gold standard? It isn't, at least in the sense that there are stricter laws. Korea has a 24-hour notice rule, not 72. Philippines and Vietnam say that their law applies to Philippine and Vietnamese citizens that live in Los Angeles or abroad, even though that data isn't even collected in the Philippines. Now, how they enforce that is a great question. And then you've got all sorts of different challenges because the law isn't implemented. The data privacy laws they're not implemented directly from GDPR. Certain concepts are. And so what I'm seeing kind of one concept that kind of goes through every law that I've looked at so far, newer law, is the data subject rights, the right to access, the right to query, the right to correct, to be able to get their data, sometimes portability. All those concepts are are GDPR stated. My friends in Korea say that GDPR actually stole it from them because they had it earlier. Who knows? But at any rate, those things are standards. And just thinking about implementing that alone for a company is phenomenally different because now you have to start watching where you have this data. Because if you're going to be able to respond to a query, you have to know, in the past, at least, the companies would gather in, personal data from whichever entity collected it. So let's say sales wanted to find out what they were selling to which customers and how they should actually, create new products. Or HR had their set of data, and it was all in different areas. And one of the things we see with hackers is they're looking for this personal data in these different areas so that they can get the juiciest bits of it, so that they can then hold you for ransom or otherwise cause you to have embarrassment or difficulties as a result. So just implementing that concept of being able to respond to data subject access requests is a phenomenal change that will take companies something to do. And that seems to be pretty universal in most all the data privacy laws, especially the new ones I've seen. But those differences, the fact that CCPA in California or CPRA says, okay, yes, we are similar in this way, but we have this really strange and different view of do not sell my data, or what it means to sell your data and the things you have to do to implement that. In order to comply in China, you don't have legitimate interest. So how are you going to justify that? And that is another huge difference, I think, from Europe through APAC and much of the rest of the world is APAC, I think, tends to be much more consent-based. We rely on getting consent in different ways, sometimes direct and express, like under GDPR. Sometimes, it's reasonable, as I think you were mentioning. And the real world challenge of this is that I've seen with a European headquartered company client that had some type of internal investigation they needed to do in India, in one of their India subsidiaries. And it involved a bribery allegation or something that the regulatory investigation they actually needed to follow up on. And they wanted to collect information from the employees' cell phones, which they sometimes use their personal cell phones, but they're dual purpose. They sometimes are used from work. All of the employees were willing to give consent to do that. But under the European model, there's this almost what I call allergic reaction to consent in an employer-employee setting. There's a belief that it's impossible for an employee to give free and valid consent to an employer because of the different in ratios. And so Europe didn't want to gather that data, when that's the only way you could actually do it under the Indian law. So if you simply apply GDPR across the globe, you're going to have a number of issues. It's not the same jurisprudence. It's not the same laws. And in some ways, you're trying to argue with local vendors a GDPR concept that makes no sense to them, and they're probably not in any position to comply with. So I think you have to take a much more structured, rational approach to which laws you're gonna put out and how. I mean, which of your privacy principles and other things you're going to implement and how locally.
Fair enough. Yeah. In fact, I have a follow-up, which I'll ask you. While you said that there has to be sort of a strategic approach for what privacy principles you'll apply across the globe. And I was wondering if you had any thoughts on that. Say if one were to launch a product in India, Singapore, Japan, Australia, say 10 key markets that you have in mind. And I'm just wondering how one could do that strategically, thinking about this.
Yeah, and I'm going to give that horrible lawyer answer, which is it depends, right? In every situation in this, you have to talk to your client to find out, okay, what are the specific countries? What is the specific data? Does it involve health records or other sensitive information? Is it potentially critical infrastructure or critical information infrastructure under China law, or important data under the China law? How does it fall under each of these countries' spectrum within the continuum, the data privacy continuum? Because once you have identified that, then you're able to say, okay, here's your highest risk points, right? And from that, you can start filtering down, okay, here's what I think you have to do. And if you're truly global, I think we've helped a lot of clients. Okay, they have a GDPR flavor, and interesting, GDPR has, all these different country flavors. German GDPR is frankly different from French GDPR, but at any rate, you've got European kind of set of rules that apply across Europe. Then you've got kind of a US set of rules, which are increasingly starting to morph to more like GDPR, but with some very interesting carve-outs for the Californias and other places. And then kind of I'm seeing an APAC flavor with addendums for these new laws like China's law, because it's so different, and the differences in Thai law and other things. If you have a really big focus there, in Vietnam, in most cases now, you're going to need a local data privacy officer. And who are you going to do that for you in China? Because that person can be arrested, right? So there's a lot of interesting questions, but there isn't one flavor that I found works for everybody. It's all a risk-based analysis that you need to walk through.
No, but I guess lots of important takeaways. No, it sounds basic, but I think that's sort of pretty important. Know which country, know what data, look at each country's laws, spot something wacky, which will tell you what sort of the ultimate risk that you can be exposed to, and take an informed decision. I guess also look at how robust the regulator is, and what you started off with, what's the trigger or objective of the law. And these kind of outliers, I think all super, super helpful. And Michelle, if I could also invite you then to talk about on similar lines, would this essentially then mean, like we've been talking about the different concepts, different nuances in approaches in these laws, does that mean you have a different privacy policy for each region or each country that you're operating in? Does it even mean a different user interface on the app for different regions? And as external counsel and as in-house counsel, how do you really help the business teams mitigate some of this uncertainty? Because there's of course a limited set of resources, limited objective that you have. So Michelle, any thoughts on that?
I'm going to repeat what Scott said. The answer to that question really depends, because obviously we have clients that like to have what they call one single global privacy policy, and then which will apply to the entire business, the entire global business. And then when you read it, there will be parts of that only apply to certain jurisdiction, but by and large, that's what they want. And I think that's primarily driven by how stringent the headquarters data protection law is. But on the other hand, you also have we also have clients that prefer to have different privacy policies, because it's the pressure from the local subsidiary. If you speak to someone in an Asian country and says you have to comply with GDPR, and if that business is actually doing very well, you're going to get resistance from that local business, and they would say, we prefer to have something that, our customers, our clients understand. So if you push GDPR to us, it's not going to work. Then you end up having slightly different privacy policies. So therefore, I think the number one thing to think about, and as Scott says, speak to the client, and also, as a business, you really need to think about which compliance of which law is the most important. Obviously, if you only have a tiny business in China, you're not going to put a lot of effort in. I'm not telling anyone not to comply with Chinese law. I'm just saying that maybe your emphasis should be elsewhere. The second thing to think about is the nature of the product and the nature of the service. That will also drive whether you're going to have a one single privacy policy or whether you need to have some differences. If we are just talking about a website, which you collect very little data, perhaps your privacy policy can be more or less the same. But if you're talking about quite a localized service whereby data will actually be collected locally, it's probably not a good idea to have a single policy with very little reference to the requirements under local law. I think the third thing to consider is, and Scott mentions that as well, some countries do have slightly more stringent requirements than the GDPR. And I'm pretty sure that the new Indian data protection law would have specific features which are different from the GDPR, in which case I think it is quite foolish to say, oh, let's ignore that and just comply with, this single global policy. I think you need to think about, at least at the minimum, treat these more stringent requirements as what they are, mandatory requirements, and try to comply with them together with your, global requirements.
Absolutely.
Actually, I just might add on that, those excellent comments is just, so take another practical example of, the European GDPR requirement to have standard contractual clauses, that those things are printed up, they're not really able to change. You're not able to do different things with those. If those were to be implemented across the globe, and let's say in particular China, well, China's law is requiring standard contractual clauses, which haven't been created yet. In order to have data leave China, you have to have consent. You have to have the China's administration, Cybersecurity Administration of China, either approve that or authorize you to do that, or somebody that they've authorized that allows you to actually move that data, or have these standard contractual clauses in place which haven't been drafted yet, right? We expected them at the end of last year. The COVID burst in China has really slowed things down. At this point, we don't know what time we'll get them, but they are going to be different from European standard contractual clauses, and they have to be implemented, and you're going to have to do a data privacy transfer impact assessment, and both of those documents have to be filed with the Chinese government, still not determined with whom, right? So we can't just implement GDPR globally and be compliant. We have to actually figure out what applies, and then, as I say, grab those concepts that are similar and try to use those across the globe, and then do your carve-outs for the extremely important places. And as Michelle says, you have to triage it. I don't want to scare people away from starting. Start somewhere, take the hottest issues, move your way down, keep going on them until you felt like you've taken care of the biggest level of risk you have, and then you have a chance to succeed.
Fair enough. No, all excellent remarks, Michelle and Scott. And just, I guess, follow-ups on that. I completely hear you on you can't simply import GDPR standards. There are several different laws. Of course, you have to go through that rigmarole of actually analyzing those laws and figuring out what works. But so we've often gotten, queries from clients saying, while we service, we have user base across the world, but we have the same set of people who will be working with, say, Indian users' data or Singaporean users' data or EU users' data. Now, do we tell them to handle that data differently within the organization? And what might that look like practically? Is it sort of one internal policy with addendum for different users? And because these questions do emerge when you're also engaging vendors, right? You'll have the same vendor analyzing data from all of these regions. So what sort of contractual protections then would you bring in? I'm wondering, Kritiyanee, if you had a view on this, or Michelle, Scott also, if you could chime in.
Yeah, to add a bit more to what Scott just said about standard contractual clause first. So Thailand, even the sub-regulation about cross-border transfer has recently been, the draft version has recently been post for the public hearing. And although again, why we draw concept from the GDPR and we have this standard contractual clause concept or SCC, the details that put in the draft sub-regulation version is different from GDPR. So this would pose another problems in terms of launching global compliance program for multinational company, right? Because as Scott said, if your company has certain physical base in EU, then you need to use the SCC from the GDPR side without having room for revision. But then if you want to transfer data from your presence in Thailand, then you need to follow SCC from Thai data protection point of view. So this will come a bit like a crash. And I think that most of other local regulations in APAC might be similar as well. So another thing to consider, as you said, Sreenidhi, is that how we can carve out the liability to as much as possible in terms of sending personal data to overseas, inbound and outbound, considering that there are some protection for each of the company within each physical presence in each countries, but also considering the global changing of the law as well. So that might be another problem that various company needs to consider. Some company use like a BCR instead of SCC for cross-border transfer, but there's a problem there as well because of certain registration requirement with the regulator, and it's not as easy as SCC that doesn't need the registration. So these are others like pro and con weighting between which agreement, which template, or what type of legal document that company would like to launch.
Fair enough. No, and I guess just from completely hear you on the challenge, and of course, but just to also look at the solutions then as to how do we approach this. So again, like if I were to take the example of there's a US business that's engaging an Indian vendor for something like data analytics, will be sending data of those users across regions, and the users could be based in India and Singapore and Thailand, Brazil and Japan. So I'm just wondering what kind of contractual safeguards then do we bring in, or do we sign different, for instance, these SCCs, then do we append EU SCCs onto it? Do we append whenever the Chinese version of the SCCs comes in, or each of them, or we start somewhere, again, coming back to the key markets?
You can probably implement 90% of a strong standard law across your organization that helps you ensure that you can deal with data subject access requests in a timely fashion. And, that could be at the most aggressive timely fashion, even though, I think in many ways, you still have some time as long as you can have that data structured in a way you can query it and respond. And you may make a global standard for that, unless there's some, unique rule that says you have to respond in a quicker time than what you had. So that you need some eyes on the local laws. In terms of the contractual side, what we're seeing with a lot of clients is that they have a basic, agreement. I'm going to entrust you with this data. Usually it's really important for any third-party vendor that's going to get the data that you have the restrictions. You're only going to use it for what I have entrusted it to you. You're not going to use it for another purpose, because that blows a number of data privacy issues up. If you don't have that, you're going to have them with the requirement to cooperate with you in the event that there's a data breach, or in that there's a data query that you need to respond to. You're going to, if they're ever collecting data, you're going to say you're collecting it under local rules, and usually it's helpful to state the specific rules that apply to the data that they're collecting. that says they're going to comply with the Thai data privacy laws, and then there's this kind of area where, you have to do what Michelle says, is you have to figure out, is this a significant enough issue that's unique for this particular area that I absolutely need to deal with this separately. And you can do that then by addendums to those contracts that say, as to any European data, this is how we're going to handle it. Here's your data privacy officer. Here's your Vietnam addendum. We need to notify you specifically who your Vietnamese data privacy officer is, right? And you can take care of each of those things in a subsequent addendum to that document. And if your business changes and you add another country, then you simply have to go back and say, hey, now we have the Philippines, and we want to try to make sure we do that. So I think it's just, again, a strategic approach, and a sensible approach to where your risks are and making sure that those things are covered. But you really need to have that third-party contract if you're giving that data out, because even in countries which don't specifically state you have to have it, it's implicit, because if you don't have it, you can't control them.
Absolutely, fully hear you. I think even in India, while we don't have a diktat as yet necessarily, but we do see a lot of clients. In any case, you do have certain clauses, at least, if not a separate data processing addendum. But maybe, Michelle, if I could ask you to sort of argue from the other side, which is the vendor side here. If a vendor gets a request, a local vendor, and they have this massive document which says you may be processing this country's law, and it's seeking a blanket representation that you will abide by all applicable data protection laws of the world. I'm wondering how one would approach that from the vendor's perspective then.
Well, I actually do have a client that has been slapped on the EU SEC, saying that they have to comply with it. So, and I have some sympathy for that request, because the customer is a global player with headquarters in one of the EU countries. However, I think if you act for a vendor and you strongly believe, after you've obviously spoken to either Scott, Kritiyanee, or myself, that actually it doesn't really apply, then I think you do need to say, look, I can't comply with or sign your EU SECs or your data processing agreements in a blanket way, but I'm happy to comply with these because these are the local law requirements. And I think it's actually quite legitimate for you to for a vendor to say that. And in fact, what we are seeing is in a lot of our global clients, what they have in place is obviously, as Scott says, some sort of generic data processing agreement or arrangement, and then where the EU SECs have to apply, then they will say, oh, Appendix 1, which is the EU SECs will apply to you. And then for China, obviously, we're going to have very interesting situations as described by Kritiyanee. If the data goes into China, maybe you comply with EU SECs. When the data comes out from China, you comply with the not yet existing PRC SECs. So I think this is an issue which I'm pretty sure a lot of the Indian companies will also face, because how you go about putting in place a data processing arrangement that comply with, first of all, India's own transfer rules, as well as where you have a global Indian business, how you then make it consistent with all these other rules you have to comply with. I think that is going to be a real challenge. And the GDPR may have been around for quite some time now. Our clients are still struggling with not complying with the EU SECs, but how then you fit that with all these other rules that are coming out from the US, as well as other countries in Asia, Thailand, Vietnam, Philippines, and China. So I think this is going to be a challenge, but hopefully some of the clients have already worked out some solutions. And so we may be able to borrow some of those solutions for the benefit of some of our clients and share those solutions if possible.
Absolutely. And on that note, I think I'm very mindful of the time as well, but because we did start a little late, I think I'll take the next 10 minutes just to talk about what you said, like borrowing from other regions, learnings from different regions as we finalize our data protection law. Just what are the tricky aspects of compliance? What are pain points, challenges, and how to go about it? Maybe Kritiyanee, if I could actually invite you into just maybe what were the sort of most challenging points or aspects of compliance under the Thai law, and the other way around as well. What's something that you thought would be horrible but ended up turning out to be pretty straightforward?
Okay, so for the first question, the pain point first is that right now various regulators in Thailand, not only the Thai PDPC, but sometimes like Bank of Thailand, the insurance commissions, they are specific regulators and have their own rules, specific rules and laws and governings like their own industry. And right now, after the Thai PDPA is out, then there are various progress from the specific regulator as well. They issue their own specific regulations about data protections for specific industry, meaning that right now some of the law from specific regulator are a bit contradicting to each other. For example, like Thai PDPA, we have some legal basis like legitimate interest for exception to consent, right? Similar to GDPR. So some of the marketing activity that would still be like expected by the data subject may not always need consent if it would not affect their fundamental rights, right? But then, for example, like market conduct rules under the Bank of Thailand regulations, they have additional laws and additional rules in terms of asking for specific consent and specific wording that must come with that consent, meaning that for banking industry, even if they are comply with PDPA and they can use some flexibility under legitimate interest, but then they are blocked by specific regulations, and this will blockade them in terms of transferring or sharing data with their own like conglomerate business as well, because they don't have only like banking business. Sometimes they have like others unrelated business governed under just only PDPA, and meaning that this type of pain point will continue to go. For example, like specific insurance law, they have their own specific law. Even life and non-life is sub-regulation for insurance are different. Some need consent and some doesn't need consent, meaning that this will create a lot of pain point for a lot of industry, and thinking more globally in terms of sharing data from one business to other business to maximize the data monetization or data analytic trends in currently in Thailand and in all over the world. This will create a lot of pain point in the future. For some company that are already finished their global compliance plan, for example, like some company who are already in compliance with the GDPR, and when they are launching their local compliance plan in Thailand, for example, like revising privacy policy, it might be easier comparing to other company that start from scratch. Some Thai-based company who doesn't have presence in the EU, that they need to start from scratch, then they need to do like data mapping, fact gathering in terms of preparing privacy policy. But comparing to those companies who already conduct their data mapping activity and launch their GDPR or overseas base, most of the subsidiary in Thailand have similar activity, and it turns out to be more easy to localize their legal documents.
Got it. Yeah. And just on, I think data mapping often also seen as sort of the starting point for compliance, because you need to know where data is. And Scott, if you had thoughts on just in the run up to the law being finalized, because a lot of businesses now ask us how long will it take for us to, reach compliance or achieve compliance once the law is enacted. So what would you advise them to do now in the run up to the law to be better prepared?
So let me take it in terms of timing first. And so much of this depends on whether there is already an existing legal framework for data privacy or whether it's a new law, right? In China, there really wasn't a data privacy law. The data security law kind of dealt with it in some ways, in some sections, but it was a brand new law. And in general, GDPR, California and other places gave us 2 years to get ready for compliance. China gave us 9 weeks. So, deal with it. The reality is that if there really isn't a data privacy regime in place, and if you haven't done some of the things that Kritiyanee has indicated, such as data mapping for GDPR or other compliance, it's not uncommon for it to take about a year. And depending upon how fast your compliance and other people respond to the questions. But the typical roadmap is you must do data mapping. If you don't know what you have, there's no way to start. So again, don't be afraid to start. Please don't let us scare you away from starting because you've got 15 countries to deal with. Start by data mapping. Figure out what data you have in your organization. Figure out where it is, where it came from. Because oftentimes where it sits now is not where it came from. And you have to apply a separate set of rules if it came from Europe and now sits in India, for example, or California. So figure out where it came from, what it is, understand whether it's, again, one of these regular personal information and realize every country defines it differently. Figure out if it's sensitive personal information, figure out if it's critical infrastructure, important or otherwise, in that fashion. And so you do your data mapping, you do a gap assessment of where you have things in place to handle the laws that apply. Did you actually collect it correctly in the first place based upon that country's laws? Did you have in place the consents or other things that allow you to collect it and use it for how you're using it, for gathering it? Do a risk assessment to figure out, where you really need to focus first to solve the issues. So that's 3: data mapping, gap analysis, risk assessment, implementation. Usually I see clients do it at various levels. They probably do the public implementation first. What's public facing? What's your website? What are the documentation that you need to be able to show the data privacy authorities? And then they start digging a little bit deeper into getting it internally. Do you have the right things in order to respond to a data subject access request? Do you have the right types of privilege forms set up for those people that look at your data, the personal information data? So there's that. And then it kind of goes in depth. Do you do training for employees? Because that's oftentimes required. And then thinking about the cross-border transfer. Do you have it in this country, but you move it to another? A lot of companies that have a global footprint have a global HR tool that they use. And the data from India or Europe or whatever are moved to headquarters because they need to say, has there been compliance training? How's this person doing? Are there candidates to be moved? They think about pay scales across. That stuff is oftentimes consolidated. But if you're not considering that data transfer, because some of it's also personal information and others, sensitive information, then you really aren't thinking about things clearly. So you do the implementation, you test whether or not that implementation is going well. And then I think my recommendation especially for in-house counsel, watch when there's new transformation of your business, when you go into new business areas, when you expand, when you take on new products, when new marketing techniques using the latest SMS technologies and others are out there and you're reaching out. Think about how that impacts the data that you've collected and where it's going. And I think then you're in position to make that transition successful.
Perhaps we could go over a little because I do want to take some of the questions that have also come in. Maybe Michelle, if I could come to you with, I think someone had a question on sectoral laws, and Kritiyanee had also spoken about this earlier, similar to Thailand, where different regulators seem to have different laws. India also has, of course, we have our baseline data protection law, but we have our financial sector regulator, the RBI, which has data localization norms. We have our securities regulator. How would you sort of, how do corporate entities then respond to such challenges? This is one question from the audience. Michelle, if you could take this one.
Yeah, and perhaps I can use China as an example, because as Scott says, the PIPL came out of nowhere. Well, it didn't really come out of nowhere. It came out all of a sudden. But before PIPL, in China, there are actually lots of sectorial regulations touching on data protection. And now with the PIPL, we continue to see sectorial regulations on regulating the use or the processing of personal information. And sometimes the requirements are more stringent than the overarching law. And there are always reasons for that. So I think that sounds like something which India is about to experience as well. And I think the reality is, if let's say you're a financial institution, you are faced with the overarching laws, that's one thing. Your sectorial laws, that's other thing. I think you probably hope that perhaps eventually the law will start to merge. But if not, then I think it is actually quite important to comply with the sectorial regulations, because a lot of the time there are very good reasons for that. The other thing is, if your business operates in reliance of one or two licenses issued by the sectorial regulator, I just think that it is pretty foolish not to comply with the sectorial requirements and try to argue that, oh, but the overarching law says I only need to do that. I think it is therefore probably a wise decision, first of all, to work out what the sectorial regulations requirements are and how do those requirements sit with the overarching data protection law. And I think this approach has been adopted obviously by China. I think if you speak to any businesses in China, they would never tell you that, oh, we're going to ignore the sectorial regulations, even though just from a legal technical perspective, it's a lower law which should follow the PIPL. That is not going to be the approach. I also want to comment very briefly on what we just talked about in terms of, oh, the law is coming, should we panic? I believe that the Indian government will be as pragmatic as any other government, but I think time will be given to the businesses to align its business with the law, because when PIPL first came about, or when cyber security law came about in China some time ago, the government did allow businesses some time to adjust the business. And to the extent that there is any enforcement action, most of the time, I think it's really out there to scare the businesses, so that they start to comply with as well. Because we also know that there are still lots of businesses who are not there, So we always say, oh, but your privacy policy doesn't really work. So I think there will be time. Some grace period definitely will be offered, even if it's not written into the law, because it's not helping the businesses to continue to function if they suddenly say that, oh, you have to do this, otherwise I'm going to revoke your license or something like that.
No, I think we do expect that there'll be some sort of a compliance window. And I think a lot of what you said about sectorial regulators also resonates, because while baseline data protection law is set to sort of, form those baseline standards, sectorial regulators will continue to play a key role. Couple of other questions I think one question from LinkedIn Live is on data retention. And Scott, if you had a perspective on this, would data retention periods differ from country to country? Is there some kind of a standard that one could follow? I think the question is around GDPR, but yeah, across the globe, how could one approach something like retention periods?
Yeah, so the way I look at data retention is, in most cases, you're allowed to keep the data as long as you have a legitimate reason to keep it. And so what's more important for most companies is to be able to state why they're keeping it and have a legitimate reason. I'm keeping these HR records because I'm required under tax laws to indicate why I had this data or that this person was employed. I also have the potential that this employee could come back at some point and sue the company for wrongful termination. So I need to have the reviews and other things in place so that I can respond to that. Have stated reasons for why you're keeping your data. And then realize that certain places are much hotter about the issue of whether you need to keep that data and for how long. And in particular, Europe is looking closely at a number of and had lawsuits related to and investigations related to how long companies kept data and whether they should have just destroyed it. And oftentimes that happens in the context of a breach, right? The breach happens, and 4 years after somebody's, data was entered, they did one transaction, the credit card got stolen. And so the question comes, how long do you really need to keep these things in certain settings? And could you have just kept it in a better way, in an encrypted format that even if it was stolen, it's not going to get taken? Again, the reason why you do that data mapping is, can I do certain steps to this personal information that I have, such as encrypt it, put it in specific servers where I have better protection and monitoring over, and the access is regulated in and out to different entities, and do it in such a way that that may not even fall into personal data. So if you do get your data breach, they don't get anything out of it unless they somehow get your keys, God forbid, right? So I think you can do different things in that setting to try to reduce that risk and handle data that you might have to keep longer. Just think about what you have and why you're keeping it for as long as you do.
Got it. Yeah. So interestingly, in the Indian draft law, the language that they use is you can retain it for legal or business purposes. So I'm guessing there'll be a lot of discussion on what the remit of that legal or business purpose might be. I'm wondering if we could take any other of the questions here.
I think Michelle had her hand up.
I just want to very briefly talk about data retention as well, because when each time this question is asked, obviously Scott's approach is absolutely correct. In some countries, there exists something called data retention law, and so you get the data, and the data retention law, which doesn't sometimes relate to personal data protection law at all, will say, oh, but you have to keep the data permanently. Now, I think that is then something that I think for us, data protection lawyer, we also need to be aware of that, and also for in-house counsel, because you can't say that, oh, I need to delete the data, or I can't keep it anymore because I don't provide this service. But completely forget about, oh, but there's actually a separate data retention law which requires you to keep the business data. I think in China is permanently, actually. So then that gives you your legal ground for keeping the data. So I think it's also important to check, once the Indian data protection law becomes effective, also try to work out how that sits with the data retention requirements, which are either apply generally in India, or if there is a sectorial specific data retention requirements which you also need to comply with.
Yeah. No, I think we've seen this play out very much in India. Like for instance, anti-money laundering laws require you to store data for 10 years and so on. I think different laws, so that mapping is also sort of essential. Perhaps we could take one last question. Kritiyanee, I think we touched upon this earlier. So Teetha had a question on standards under different jurisdictions when it comes to cross-border data transfers. In the case of transnational transfers, how could one sort of impose enforceable obligations on the recipient?
Thank
when
you.
the recipient is outside the jurisdiction?
Mm-hmm. Okay, so for the standard first, I guess like we already discussed from Scott and Michelle's, like various type of VCR or SCC, and also sometimes we entered into like a direct agreement for data transfer agreement with each specific counterparty from the transferring and recipient countries, because it might be better to use like SCC and BCR to govern all of the jurisdiction. Sometimes it might be better to know your audience, know your destination countries, and draft a specific direct data transfer agreement to be in line with the transferring country and also the recipient countries overseas. And in terms of actual enforcement, I think that's right now, even the regulator, like in GDPR based or even in Thai draft law version about the cross-border transfer, there are one clause like empowering regulator, the data protection regulator, to like seek cooperation and to say like evidence to cooperate with others foreign data protection regulators as well. So that might be another trend to watch out for, whether this law empowering this government, this specific regulator in each country to collaborate, to exchange their evidence, to exchange their requests from data subject, whether this will actually lead to some important enforcement in terms of cross-border data overseas to various jurisdictions.
That's very interesting, actually, information sharing and some kind of reciprocal arrangements, because our transfer provision for cross-border in the Indian law is fairly open-ended, and we have heard that maybe reciprocity is something that's sort of considered here as well, and it'll be interesting to see if this is the direction that they go in. I am very mindful of the time, and I've kept you guys over what we'd originally planned. Thank you so much, Kritiyanee, Michelle, Scott, for your time. This was incredibly useful, and yeah, on behalf of everyone at Ikigai and IBLJ, thanks very much for your time.
Thank you. Bye-bye.
Great. Thank you all.
Thank you.